Why has the subject of litigants in person become such an important issue? It might be worth pausing for a moment to define our terms. A litigant in person is the term used in all criminal, civil and family courts to describe individuals who exercise their right to conduct legal proceedings on their own behalf. Please note that it is a right, and they have chosen to exercise that right. There are a variety of reasons why the subject is important. Part of the answer lies in the fact that we, as family practitioners, are meeting with litigants in person on a far more regular basis. These include practice areas such as injunctions, children, divorce, and finances. Whilst litigants in person have always been able to conduct their own cases, there has been an enormous increase over the last few years. This has meant that we need to think carefully about how we approach cases where our opponent is unrepresented. Let me give you a few practical ideas on how to help on the day of the hearing. The first thing I would say is that you must encourage unrepresented opponents to engage with you. Now, this sounds like common sense, but it doesn't always happen. Certainly, the court will expect you to have made attempts to resolve matters by agreement. If you don't try, the court may put the case back to allow discussions to take place. I realise this may not come naturally to you or a litigant in person in an atmosphere of success or failure, but you do need to try. Take copies of documents to court. It is amazing how many litigants in person fail to bring their own copies. Handing over a further copy might even win a friend or gain unexpected cooperation. When you arrive at court, check what documents have been filed at court by the litigant in person. Check with the litigant in person first, and maybe with the court after that. That way, you will not be taken by surprise when the district judge points out that the litigant in person has filed a bundle of documents, none of which you've even seen or been made aware of.